Hello YouTube, I am Vince White. I am an employment attorney and I am in the movie Escape from New York. I'm trying to escape from New York, but there's a snowstorm coming and I'm worried my flight may be canceled, which would be tragic because New York City is not really a very fun place to be anymore. We have a question here. Oh, I'm an employment attorney. I answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. And I should have led with that instead of telling you that I'm trying to get out of New York, because you don't care and you shouldn't care. I'm not important. All right, we have a question here from YouTube user Paul Watson, who asked us, great video, well, thank you. I did have a question. If possible, it's a federal court question. It is indeed possible. Can defense counsel choose not to submit an answer to the complaint by the deadline, instead issuing a motion of dismissal as their answer to the complaint? If so, why can the plaintiff not request to the court judge a default judgment against the defendant? Okay. So I'll break this down. There's a couple different components to this. First question is, can defense counsel submit a motion to dismiss instead of an answer? Yes. And why can they do that? Because a lot of complaints that get filed are not drafted correctly and fail to state a cause of action or fail to state a claim, right? There's a lot of people, a lot of attorneys, frankly. There's a lot of pro se people, too, who just don't know how to write a complaint and will jot some nonsense down on a page and be like, pay me! And it's like, well, that's not how any of this works. And I'm sure that's not what you did, but I'm saying why this mechanism exists, right? So there's just a lot of junk complaints that get filed. A huge percentage are just nonsense. Like I've had to call attorneys and be like, hey, I looked at the complaint you filed. Obviously not an attorney in a firm, but I've looked at the complaint you filed. That's frivolous. You failed to state a cause of action. Like, you're just vomiting nonsense onto a page. And not for nothing, you're admitted to the bar, so like, this is a real problem for you. Like, this could be sanctionable. You're wasting the court's time, and if you took money to do that work, you're harming people potentially. But one of the mechanisms to keep those cases short is to have this motion dismissed that takes place before the defendants file an answer. Now, if their motion to dismiss is not granted, or if they're not allowed to file the motion to dismiss, there's things like that can happen. They still have a chance to file an answer. It's not like they're going to be in default because they utilize this process to file a motion to dismiss before they answer. The process is built specifically to let people do that in situations where it's appropriate. I'm not saying it's appropriate in yours. I have no idea. I don't know the first thing about your complaint, and I don't know what's going on, and maybe this defendant is an idiot who's just trying to be overly aggressive and doesn't know what she or he is doing, right? So let's go on. What's the next part of the question here? They can do it, yes. I guess the next part of the question, why can the plaintiff not file for a default judgment against the defendant? Okay, so there's two ways you could mean that. I think the first way is you're assuming that they're not answering, so they're in default, so you should be able to file for a default judgment. No, that's not how that works. Specifically, if you file a motion to dismiss before the answer, there's a process by which the time to answer is extended. That will be handled in the motion practice and should have been made clear by the filings and by the court. It's also going to be in the part rules, usually stated pretty clearly in the judge's rules. So if you're in federal court, usually the judge's rules are online. And obviously, the rules are different everywhere. Like, I'm talking in the context of New York, so, and the Southern District and the Eastern District of New York, and occasionally even the Northern District of New York. But, like, you need to check the local rules where you are and talk with local counsel about how things work locally where you are. There is significant variance from federal court to federal court. People do things differently. Dockets are run differently. Procedures are different. It's not all perfectly cookie cutter and uniform, so be aware of that. But if your question is, haven't they exceeded time to file an answer, so I should be able to file for default, the answer to that is no, they haven't. That's not how that works generally. Check the local rules to see how that operates where you are. If your question is a broader, hey, if they can file a motion to dismiss, why can't I file for summary judgment? The answer to that is a little bit more complex. First and foremost, a motion to dismiss and a summary judgment motion are two different things. They have different standards. They serve different purposes. They're both dispositive motions. They can both dispose of a case in different ways, but they're not the same thing. The similarities really stop there. So, like, for the motion to dismiss, what they're really, and I'm paraphrasing and I'm being really colloquial and, like, loose with this, so these are not legal standards necessarily, or at least where they are legal standards, I'm using them in common parlance as a layperson to lay people, because, you know, this is not legal advice. We can't really know enough about your situation to offer you legal advice ever. It's just not going to be possible on this channel. So, when you see a motion to dismiss, what you're seeing there is they're essentially arguing, hey, even if we assume everything in the complaint is true, Judge, let's assume everything that plaintiff said is true. Still not a claim. They can't win. That's what they're saying with motion to dismiss. That's why often motions to dismiss are either a really bad sign, in that you or your attorney have done something wrong in your complaint, or two, it's a sign that your defendant has money to burn and they're either getting taken for a ride by their defense counsel, which really happens sometimes, or they're trying to fight like this Pyrrhic victory of like scorched earth. We're gonna run through your litigation money chest and try to wear you out, which isn't that realistic and isn't that common in employment litigation, because firms tend to not charge by the hour in this field, so that's probably not going to happen to the average claimant, the average plaintiff, right? So those are the two reasons why you might face a motion to dismiss. There's an issue in the complaint, and listen, motions to dismiss happen, and they can often be, I guess the third way it happens is you have a reach claim in there, right? You've got maybe 10 claims in your complaint, and 7 of them are well situated on the law, and 3 of them you're like, well, these are battlegrounds. The case law is a little unclear. We're trying to extend a little bit here. We're making a push. We think this claim is viable, but like a judge might have to rule in a motion to dismiss on if this claim goes forward. So that's really the third way that a motion to dismiss might crop up. But that is essentially what it is. It's assuming that everything the plaintiff is saying is true in the complaint, and they're arguing some of these claims still shouldn't be able to go forward. Some or all of these claims, right? That's what they're arguing. Now, summary judgment motion is going to be something that happens after discovery. And summary judgment motion is going to take a pause after discovery and look around all the deposition transcripts, all the interrogatories, the document discovery, and it's going to say, hey, this is the stuff that gets to go forward as evidence at the trial. And there's no way you can put together a case with this discovery that says this plaintiff is right. Or, conversely, the plaintiff could argue, hey, look at this discovery. There's no way, if you go forward to trial with this discovery, that the defendants can prove they're not guilty. And that is, as you might imagine, a very, very high bar to jump over. It's a high standard to argue. It's very difficult. Summary judgment cases can be difficult to get granted, at least in their entirety, right? And generally, where they are granted, it tends to be that the facts weren't necessarily quite the way one side or the other represented them. And then discovery came and slapped them upside the head and said, hey, remember me? I'm reality. I'm how things actually happen. You were dumb and believed your own lies. Or there's things you didn't know and now you know, right? Like, that happens. And that's often what happens when you see summary judgment get granted. It's just the facts aren't what one side or the other thought they were. And it's so overwhelming that now, based on that, there might not be a path forward. That's what summary judgment is. So if you're asking why can't the plaintiff just file a summary judgment motion early on, it's because you haven't had discovery yet, right? But I suspect, as I reread your question, I suspect your initial question was just like, hey, aren't they in default because they haven't answered? Can I file for default? And the answer is no. There's procedural elements as to why that's not the case. Anyways, Paul Watson, I hope this was helpful. I'm going to keep it under 10 minutes, and if it was helpful, like and subscribe. Helps me to help more people just like you.